Day 500 million of the Young Thug trial. Y'all know how this is. No cuts, no edits. We're going to do another live reaction, live view of this motion denial. So, spoiler alert, Judge Glanville denied the motion to recuse himself from the Young Thug case, as we knew he would, especially if you reside and if you work and do cases in Fulton County. You already knew the judge was never going to recuse himself from this case. And so there should be no surprise there. But let's go over the hearing. Let's see what he said. Let's hear his logical reasoning. Let's hear the arguments from the attorneys. And I read this motion. I just did a video on that. Hopefully it goes up tomorrow. And I thought the motion was very well thought out. I thought the arguments were excellent. And I definitely think he should have, at a bare minimum, he should have handed that case off to another judge to review and look at and decide the motion to recuse. At a bare minimum, I think he should have done that. I think that would have been ethical and right and just, but he obviously feels differently than I do, as he has, no tea, no shade, a lot of this case, a little tea, a little shade. So let's get into this and let's hear what he said.
This applies to both motions that have been filed to recuse the court or disqualify the court. Recusal by a Superior Court judge is governed by Uniform Superior Court Rule 25, etc. Rule 25.1 provides that all motions to recuse and disqualify a judge presiding a particular case or proceeding shall be timely filed in writing, and all evidence thereon shall be presented by accompanying affidavits, which shall set fully assert the facts upon which the motion is founded. Filing and presentation to the judge shall not be later than 5 days after the affiant first learned of the alleged grounds for the disqualification, and not later than 10 days prior to a hearing or trial.
All right. So basically, they had 5 days to file the motion to recuse Judge Glanville. They filed it right away. So they definitely made it within that 5-day deadline. So that's, check. There's another requirement that he's going to talk about soon, check. So really the most important requirement here is number 3. If everything is taken as true, would the facts in this case rise to the level of recusal? So if all the facts of the case, right, Judge Glanville had this ex parte meeting, Brian Steele was required, or he was sentenced to do 20 days in custody, although he doesn't have to do those days anymore because the Supreme Court of Georgia tapped in. But, if all of these situations are true, if all the allegations made in the motion are true, does that mean that a recusal is warranted in this case? That's what the judge is going to have to decide, and that's going to be the key point in this case.
Subject of the recusal or disqualification, unless good cause be shown for the failure to meet such time requirements, and that is cited in Georgia Uniform Superior Court Rule 25.1. So I'm applying that to both sets of motions to recuse. And applying this rule, Georgia courts have held that when a motion to recuse is filed, the trial judge shall immediately, 1, determine the timeliness of the motion, 2, the legal sufficiency of the affidavit, and 3, the legal sufficiency of the grounds, and has no power to do anything else. And that is Robinson versus the state. 332 Georgia Appeals at 240.
Legal sufficiency is the key there. That's what I was talking about earlier. And that just means, as I said, if all of the facts are true, does this rise to the level of recusal, right? That is what the judge is going to decide here. And he's going to, of course, decide this in favor of himself staying on the case.
4241. The 3 threshold determinations that the trial judge must make in regard to a motion to recuse are whether it's timely filed, whether the affidavit made in support is legally sufficient, and whether some or all the facts set forth in the affidavit are true. Recusal would be warranted, and that is Dacker versus the state, 300 Georgia 74-77 2016. The judge finds any 3 of the conditions have been met. No, I'm sorry, take that back, strike that. If the judge finds that all 3 conditions have been met, he must refer the motion to another judge to hear the motion. But if any one of the conditions is not met, there is no error in denying the motion. And motions to recuse are viewed and considered by the appellate court for abuse of discretion.
Which basically means unless I fucked up, abuse of discretion means unless I fucked up majorly, then the appellate court is not going to do shit.
Accordingly, the court is going to address each one of the factors as it pertains to both Mr. Steele's motion and, for shortness, Mr. Banks' motion. I find both motions were timely filed. I find that Mr. Steele's motion was in fact filed on this past Monday, which would have been the 17th of June. I find that Mr. Banks' motion on behalf of Ms. Bumpus was timely filed, as it was filed on the
It was filed timely. Spoiler alert.
filed on the 14th of June at 10:40 p.m. Secondly, I find that in addressing the legal sufficiency of the affidavit, that means, was it sworn? Was it sworn before a notary is in proper form? I find Mr. Williams and Ms. Bumpus's motions to be, or I should say affidavits, to be in proper form. The third thing.
Well, an affidavit is just a statement at the end, a sworn statement, where the attorneys in this case were talking about the incidents, that the great contempt incident of 2024, how it happened. Kayla Bumpus was talking about the motion to show cause, or the show cause order, and her having to show up. So they're recounting the facts as they remember them, and really as they happen, because you can really just turn on YouTube and watch what happened. So that's what an affidavit is. It's really essentially a signed statement, sworn under penalty of perjury, and that's that. Nothing too crazy.
Thing that the court has to review, and like I said, I reviewed, is the legal sufficiency of your grounds of the motion. And
get to the good stuff. Come on.
And here's where the court finds that upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state.
Let's look at so yeah. That's a record fucking denial. Not really, because we've had one deny faster than that, but that was crazy. So he looked at it, he read it, he said, denied. I'm going to invite y'all to look at the state versus Baptiste, and let's pull up the state versus Baptiste real quickly. He didn't give us a site, but let me see if I can pull that up, because he basically said that they just made bare assertions and legal conclusions, but that wasn't sufficient for a motion to recuse. And I am super interested to know why the heck he is saying that, but he didn't give us a case site. So let me come back to that. So put a pin in that for a moment, but let's get through the rest of this and see what happens.
Just because adverse rulings have been made, doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of the motions to recuse to an order, and I will.
Okay, so he's gonna write
file that so you can take whatever.
So basically, he said that's what that case he just quoted stands for: the notion that just because a ruling has been made against you, doesn't mean that the motion to recuse should be granted. I think a little bit more happened than that. I think way more happened than that. I mean, if you read the motion, they were talking about the ex parte conversation, the fact that he got on defense counsel instead of addressing the ex parte conversation, the fact that he held defense counsel in contempt, even though defense counsel was saying that he was complying with his multiple, ethics rules, statutory rules, all that stuff. Multiple violations were committed. And that were going to hinder him from presenting his case for his client rather. And the judge ignored all of that, held him in contempt for 20 days. They had to file an appeal, all that good stuff. So there are more, and there have been instances, quite frankly, throughout this entire trial. But the judge basically said, nah.
Steps you need to necessarily after that. But I don't get into anything about the affidavit itself argument on that. I just have to read it. Those are the only three things I do. And then if I find it to be not sufficient on space, I go for it. I just make the ruling at that point in time, let you all take it up. No, I won't grant a motion for a certificate for immediate review. And that's where we are at this point in time. Anything else, Mr. Banks?
Jesus.
If I could just briefly be heard, Judge.
Sure.
Well, please. And I'm not trying to, I understand the court's ruling and we'll proceed as we see fit. I do take issue with the court's
Summary denial.
Characterization about the legal insufficiency of the affidavits.
Well, that's why when it was reviewed on appeal,
Sure.
it can certainly be. I mean,
There we go again. This man is so constantly. You hear again. You can just when it's reviewed on appeal, you can see what the appellate court thinks. But right now in this court, in my kingdom, denied. I mean, again, you have to kind of wait for this appellate review to happen, and I mean, that's ridiculous. God, when is that going to happen? I mean, sure, the appellate court, the Supreme Court stepped in quickly this time regarding the bond, but regarding this issue, I mean, we don't know when that's going to happen.
Will review my ruling for abuse of discretion.
Certainly understand that, Judge, and in stating that, Judge, I would just say that one of the issues that is raised in our affidavit, because our motion to recuse is to recuse you from the contempt proceeding,
right,
not the underlying criminal case in which Your Honor is presiding. And so we really don't have an issue or standing to even challenge that. And so to the extent that there is a contempt proceeding that is set for the 25th, Your Honor, you are a witness to that proceeding.
Right.
And so because you were a witness.
So again, there's a distinction here. So there's a distinction between a motion to recuse Judge Glanville from the entire trial, from Young Thug's trial in the entirety. And what Gabe Banks is saying is no, their motion is to recuse Judge Glanville from the contempt hearing. That's it, just the contempt hearing. That is what they're saying he should be recused from because he's a part of that case. He's going to have to be a witness because he had this ex parte conversation. So they're going to have to question him regarding that conversation, how it came about. They're probably going to try to question him about what happened in that conversation or what he said, but I'm sure he's not going to answer that. But he's a part of that case. So how are you going to be the judge on a case that you were also presiding over, rather that you were also a witness in? You see what I'm saying? You can't be the judge, the jury, the witness. You can't play all of those roles, and that's what's happening here.
Witness.
I don't believe you. I'm not going to get into any argument, but I can't. So that's your assertion at this point in time. And like I said, when that is taken up, I'll consider it. I also remember, I still need to rule on the issue of the motion to quash. So I may, depending upon what I decide to do at that point in time, other things may be ripe. Okay.
Do you want to hear about the motion to quash or you want to take
No, not yet, sir. I'm going to take up the motion to quash after I finish, we finish the direct of the current witness.
Okay.
And to other issues that have been raised, as I've told some of the other lawyers here, there is a transcript of what occurred in the ex parte matter.
Mm-hmm.
I will, in fact, I'll authorize defense counsel. I'll do a privilege review and see what needs to be disclosed in terms of impeachment and/or Brady, and for that, and I will do that. And then so if that pertains or if that issue affects you, then certainly that may be something that.
Okay, so basically he's saying that he's going to review the transcript of the ex parte conversation and see if there's any information that needs to be revealed to defense counsel or any information that cannot be revealed to defense counsel. And if he finds anything that needs to be revealed, he will absolutely do that. I mean, he'll have to tell defense counsel about that. The prosecutors really should have done that, but he will do that as well. And again, people have been asking, why won't he make the transcript available, or why, will he redact some portions that are privileged, I guess, and then make the transcript available? He has not said anything about that up until this point, and he hadn't confirmed, I don't think, that there was a full transcript. He said something about a transcript, or it sounded to me like the court reporter might have been in and out, but now we hear that there was a transcript of the conversation. The only thing we heard before was the appellate court will have access to the transcript if they need it. So now this is nice to hear affirmatively.
At the appropriate time. you'll be able to have a look at.
Okay,
Well, I
perfect.
appreciate-
So the court is now saying that he will give over that transcript. That's good. I mean, I'm glad. This is certainly a change of pace from last week, because last we heard, you're not getting that transcript. The appellate court will get it, and if they think I'm wrong, they'll tell you. But now we're hearing that there will be an opportunity to review the transcript. I'm telling you. I mean, he just has to take some time to think about this. It feels like sometimes these rulings are made in anger and in haste, and he doesn't say. I think it's questionable, right? The motives can be questionable, and you don't want to have that as a judge. You don't want to appear that you're not making the right decisions, or that you're making decisions based on bias, but it's too late. We're already here.
If court's time, we would certainly rely upon our brief and our
Yeah.
motion, and that's a part of the record.
Okay, all right, but I will reach out. The court will reach out to you on two things. One, the ability to take a look at the ex parte transcript and review it for the appropriate parts that the court will authorize. And then also for the, I'll re-notice you, because I know that it's supposed to be done this Tuesday, but I doubt that we'll probably have it this coming Tuesday.
If I just may say, again, Judge, I know I've already said it as it concerns the issue about you being a witness to the proceeding. We don't believe that that's a bare allegation. We believe that would be an established fact at the hearing. We also.
But I can't take it. It's not something that I can argue with you at this point in time.
I'm not trying to argue.
No, sir. You are an advocate for your client.
Sure.
That's the only thing I can say, but I'm not going to take up that issue right now. It's part and parcel. You've made it part and parcel of the motion to recuse. So I'm saying that at this point in time, I've made my ruling. You've said what you need to say in terms of what your thoughts are. I'm going to reduce it to an order, and you can take what you want to after that. Okay.
All right. Thank you.
All right. Thank you, sir. All right. Mr. Steele, similarly, I'll reduce what I have mentioned to in an order, and you will be able to take.
So basically what that attorney, Gabe Banks, was saying was that there's a statement in the motion that says the judge will be a witness in the contempt. He's saying that's not an allegation. That's not an argument. That's a fact. You're a witness to the case. And the judge is saying, well, I can't take that up with you. I'm not allowed to do that. That's it. I can't really argue with you about that. My decision to deny the motion to recuse stands. So what the attorney was trying to do was just get that on the record. And the judge was saying, the subtext there was the judge was saying that it is a part of the record because you made that part of your motion, which is going to go up to the appellate court. So the receipts are there, and the appellate court will be able to see that. You don't have to argue it in front of me here.
Pick it up as you see fit. I'm not going to grant a motion to a certificate of immediate review. Anything else?
I have read Baptiste versus State. I've read all the cases that I believe are applicable. I'm, best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion, where a person that they represent was in a meeting, ex parte, with the court and others, and the prosecutor and a witness, and specifically, they wrote in a pleading and under Parish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal, 392 Division 1, 2022, the lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams. So I just asked you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely.
And I have to pause there because it really speaks for itself. You are a witness in the trial now. I'm putting you on the trial list. I'm on the witness list. I'm putting Ms. Hilton on the list. I'm putting Ms. Love on the list. Those are the two prosecutors. I'm putting y'all on the list because I'm going to ask Mr. Copeland about this meeting. Did he feel pressured? Did he feel like he had to testify and say something because he didn't want to spend some indefinite amount of time in custody until the end of this trial, which the judge allegedly said he was able to do, or not the judge, but the prosecutor said the judge could put Kenneth Copeland in custody, place him in custody until the end of the trial. Did you feel pressure? Did you feel like you had to testify after you heard that? And Brian Steele said when he gets an opportunity to cross-examine Kenneth Copeland, he's absolutely going to ask him about that. And as a result, the judge is going to be a witness. And that same judge is also going to be the one that's instructing the jury. Like, come on. This looks horrible. This looks horrible. How are you judge a witness in the case and then you're going to give me, and then you're also presiding over the case? The fuck? You wouldn't be allowed to do that anywhere else.
I don't believe that meets a legal conclusion or a bare assertion. I asked the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
I also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it, there is zero privilege. So I don't understand
I'm not gonna, Mr. Steele, I can't argue with you about anything such as,
so again,
I've made my ruling, okay?
we're just back and forth as to whether the conversation was privileged or not. The judge is saying that there are portions of the conversation, maybe, I don't know. He's going to say he said if there's anything privileged in the transcript, which means something that he doesn't have to let the lawyers read, as he claims, then he's not going to turn that over. He's going to redact that or delete it, whatever, take those portions out and then turn it over to the defense attorney. The defense attorney is saying there should be no redactions because there's nothing privileged. There was nothing privileged about this conversation. The conversation should not have been happening. I should have been there. I need to read it fully and in its entirety. And he's saying there's no privilege, so I need it all. And the judge is saying, well, I can't really argue. He's going back to that. I can't really argue with you about that. Let the appellate court decide when it's time.
If you have some other basis to ask for,
that's wild,
the recordings or anything like that, you're going to have to put those in some other pleading. But at this point, Ms. Weaver is going to prepare the record. She does that. And like I said earlier, the record should be ready soon. And you all, as a defense group, will have the opportunity to take a look at that particular ex parte transcript that was done in chambers, less anything that is totally that the court considers to be privileged. And I'm going to let you do that before you examine Mr. Copeland. So you'll have everything that you have at that point in time.
Thank you.
All right.
Well,
okay. All right. Let's turn now to the statements or interviews from
and that's it on the motion to recuse, baby. Quick, fast, and in a hurry. So motions denied. And again, something that we're gonna have to deal with on appeal. I read the motions. I read the motions for recusal. I read the motion to quash. And I thought they were sufficient. I mean, I thought in a world where everything was happening in the way in which I think it should happen, I definitely think the case should have been sent off to another judge. That didn't happen here. I'm not surprised. How many judges do you hear recusing themselves from cases when they think they should? And it does happen. It certainly does happen, but it doesn't happen as much as it should. So he's going to stay on the case and the trial is going to keep moving as normal. That's it for the motion to recuse. Thank y'all for tuning in. Let me see. Do y'all want to hear about the State versus Baptiste case? Let me know, because I'm not going to pull it up now because I feel like I'm already at conclusion. But I love y'all. This is one of those raw, unedited kind of takes where we just watch it and I say my thoughts in real time. So if you want an edited video, I will do that another time. See ya later.